5 seconds to go. Start. Council relied upon the affidavit filed by the director on 3rd August 2018, which clearly stated that the order dated 20th June 2017 merely sanctioned higher grade and had promoted medical officers as per the ratio of 1:3, and the officials were allowed to continue under the same institutions. It was a categorical position of the department that no vacancy arose in the entry cadre. The affidavit further stated that 16 vacancies arose in medical officer Ayurveda post. Among this, one vacancy was filled up by resigning of a medical officer. Balance 15 vacancies were reported to Kerala Public Service Commission, and appointment was given to candidates as per the advice list from the Kerala Public Service Commission. It is submitted that government have reported total number of 158 vacancies in the medical officer Ayurveda, including the above 15 vacancies, and as per the advice list from Kerala Public Service Commission, 158 candidates were appointed from the category. 5 vacancies were set apart for physically handicapped candidates by Kerala Public Service Commission. It was argued that the CAT's directions have the effect of disturbing cadre strength of medical officers in the department. Besides, the directions results in the appointment of candidates were in numbers excess to what the rules would permit. In this context, Learned Council relied upon Rules 13 and 14 of the Kerala Public Service Commission Rules of Procedure 1976, hereafter referred to as Rules. Mr. P.B. Suresh, Learned Counsel appearing for the respondents, that is, those who were applicants before the CAT, argued that this court should not interfere with the impugned orders. Learned Counsel contended that although in terms of the rules the life of the ranked list was 2 years, nevertheless it was extended by 1 more year. Council submitted that Rule 14 of the rules obliged the KPSC to advise candidates for all vacancies reported and pending before it, and vacancies which could be reported for the period during which the ranked list was alive. It was therefore submitted that the department's omission to report 28 vacancies and other additional vacancies which arose on account of the promotions of incumbent medical officers to the post of senior medical officers entitled the candidates awaiting appointments and whose names were reflected in the rank list like the applicants to seek judicial remedies. The CAT, after thoroughly examining all the materials and considering the contentions made before it, correctly held that there were adequate vacancies which had to be reported. The department did not disclose any sound rationale for not reporting such vacancies. In these circumstances, the interim order dated 14th November 2017 was meant to and did complete justice to the parties. Learned Counsel particularly relied upon the reasoning of the CAT in its order dated 3rd February 2018 in OA number 1900 of 2017. He submitted that the CAT took note of the government order dated 20th June 2017 permitting 115 medical officers to the post of senior medical officers, which resulted in 115 vacancies during the currency of the ranked list. These, in terms of Rule 14, had to be reported. The absence of any sound reason for not being reported justified the CAT's final operative directions. Mr. Noor Mohammed, learned counsel, appearing for some of the applicant candidates, also relied upon Rule 14. He further contended that the department's position that the CAT's order with respect to vacancies arising after the promotion order dated 20th June 2017 is justified. Those vacancies necessarily had to be reported to the KPSC for appointment and further process. He also submitted that the posts and promotions were governed by the Indian System of Medicine's Kerala Service Rules 2005. It was submitted that the relevant category of posts, that is, senior medical officers, were to be filled only by promotion from the cadre of medical officers. The Departmental Promotion Committee convened for promotion of 140 medical officers to the post of senior medical officers, which resulted in 115 vacancies. This was consciously taken into account. The order was also considered by the CAT, which issued directions. In these circumstances, the High Court was justified in rejecting the department's writ petition. Stop.